Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. Don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Hello, everybody. We have a dual live going on right now. We have the Devyn Michaels sentencing, and we are going to just hop on over because we are live right now in the Uvalde Adrian Gonzalez trial. So we're doing dual live. Okay, so let's get over into the Devyn Michaels hearing and watch that.
Mr. Brown, can you approach? Mr. Pinnell is here on his behalf. Mr. Pesci is here on behalf of the state. This is daytime set for the defense motion to continue the trial that's set for January 20th, as well as calendar call. Mr. Pesci, have you seen the motion?
Yes, Your Honor.
What is the state's position?
We submit this.
All right. The motion, Mr. Voter, sir, you understand what's happening?
Oh, yeah.
Is that a yes?
Yes, ma'am.
All right. All right. I'm gonna grant the motion to continue. The jury trial is gonna be vacated. Did you guys discuss when you wanted this reset?
Yes, Your Honor. My client has consented to continuing it. He has some reservations about how long it might take, but I think based on Mr. Pesci's schedule and my own, September works best.
Okay, Ms. Pesci, anything else you want to add?
Yes, there was some conversations about June. Unfortunately, I have three, not unfortunately, but I had three set in front of you in June, so I don't think I could pull that off.
I guess I'm not going on vacation in June, Mr. Pesci.
I didn't set that.
All right, let's go ahead and let's set the jury trial for September 14th.
Your calendar call can be September 3rd at 9 a.m. Your pre-trial conference is going to be August 27th at 9 a.m. And your status check trial readiness will be April 9th at 9 a.m.
Thank you, Judge.
Thank you, Your Honor.
Is that all you have, Mr. Wood?
That's right, yes.
Okay. Mr. Delente, what are you here on?
I'm on page 14, Vasquez Machado.
Okay. Let's go to page 14, C, 389906, date of birth, Julio Vasquez. May the record reflect that Mr. Vasquez is present in custody. Mr. Delente is here on his behalf. Ms. Mercer is here on behalf of the state. Mr. Dayton
Is here.
Well, Mr. Martinez is here. Mr. Sheets, on behalf. Anybody from the state of Nevada? Mr. DeJoffin is here on behalf of the state. This is daytime set for the defendant's motion to dismiss counsel.
I'm
Mr. Davis, is
hoping
your desire
because
to
these
continue
are a
forward
bunch
with
of
that
people
motion?
we're not interested
All right,
in.
I'm gonna set this down for a young hearing. Monday morning, January 12th. All right, let's go to page 19. See, they reflective prison. Mr. Youth. You called them so that you could give us an update as to whether or not they're gonna get him to the video room.
I will do that.
Go to page 16, A873070, Michael Rodriguez versus the state of Nevada. Make the record reflect Mr. Rodriguez is not present. He's in custody at Nevada Department of Corrections. Ms. Lowe is here on his behalf. Mr. Pesci is here on behalf of the state. This is daytime set for further proceedings from the Supreme Court, so we need to set this down for an evidentiary hearing in regards to claims 1 and 4, based upon the Supreme Court order. Have you guys had?
Let me, one moment, please. Witnesses two things, so, yes, he did.
So you're, that, Mr. In custody, Mr. Patrick is here on his behalf. Mr. Palal is here on behalf of the state. This is on for the state's motion as well as the statute EMP. What happened to the new case?
So Judge, the new case was dismissed as expected on Tuesday. I'm sure the court read the police report.
I did.
Mr. Palal read the police report. Chatting with Mr. Palal yesterday, I'm going to ask that Mr. Hill be released today on the original bond and house arrest. And I believe Mr. Palal is going to have no objection.
I would say that if you read the police report, you would also realize that the defendant admitted to having an extra phone that he was hiding from the house arrest officer, which I think is probably less than the behavior one would expect for somebody who got a $100,000 bail on a murder that's on video. So that I would suggest that maybe a little less glibness would be appropriate given the circumstances here. That being said, I will submit to the court regarding the defendant's custodial status.
Okay. All right, so Mr. Hill, you understand the concerns based on what Mr. Palal stated. You're not allowed to hide phones from the house arrest officer. Do you understand that? All right, you understand this court doesn't tolerate new cases under any circumstances. So I'm going to reinstate your original release conditions because that new case was dismissed. All right, so today you're going to be released back on house arrest with the previous bond already having been posted.
Thank you, Your Honor.
Thank you. All right, is anybody here on the fields?
That's my case. It's with Mr. O'Brien.
Okay. Ms. Stanley, can you find out where Mr. O'Brien is?
Okay.
From our office, Joe? Yes. Yeah, he's actually out sick today. I just got a text from him.
Okay.
So I'll figure out what's going on.
Okay. Mr. Helmut, you ready?
Yes, ma'am.
Let's go to page 2, C 395-950, State Nevada versus Tyler Johns. May the record reflect that Mr. Johns is present in custody. Mr. Helmut is here on his behalf. Mr. DeJacquilo is here on behalf of the state. This is the day and time set for continued arraignment. State, I do not see a notice filed as of this morning. Is this?
We are not taking that.
Okay, in light of that, Mr. Helmut, are you prepared to go forward with the arraignment?
We are.
All right, Mr. Johns, sir, what is your full name?
Tyler Matthew Johns,
How old are you?
20, not guilty. Your Honor.
From the,
If you could submit those documents to the court, and if they have documentation that he refused transport to the hearing today, the court is gonna rule on the pleadings and just issue a written decision.
yes, Your Honor, I will get that submitted as soon as possible.
Okay,
March 12th at 9 a.m.
Thanks, Judge.
thank you.
Thank you.
Thank you.
Thank you, Mr. Newman.
Your Honor?
Yes, just 1 second.
Oh, no rush.
Custody, Mr. Fayad is here on her behalf. State of Nevada versus Devyn Jackson. Mr. Delancey, how far did you go?
Yes, ma'am.
They still have not the Devin Michaels.
Is that a yes?
They're doing-
Sir, are you currently under the influence of any drugs,
Is it
medication,
live?
or alcoholic beverage at this time?
Medication.
Does that medication
We are
in any way affect your ability to understand the proceedings that are happening here today?
No.
You understand the proceedings that are happening here today?
Gonzalez trial
Sir, are you familiar with the 2 charges that you're
for
facing?
both
Do you
law.
understand those charges?
Thank you so much for joining
After
me.
those charges, how do you plead? Guilty or not guilty?
Not guilty.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
I'm gonna vote.
Okay,
Allergy mags make it hard to stay awake.
all right, let's go to Ms. Williams. Ms. Williams, ma'am? What is your full name?
George Siobhan Williams.
How old are you? 33? How far did you go to school?
I'm I don't know.
High school.
It could have been the
Okay,
only.
do you read, write, and understand the English language? Yes. Ma'am, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time? Do you understand the proceedings that are happening here today?
Yes, ma'am.
Ma'am, are you familiar with the two charges that you're facing?
Yes,
Do you understand those charges?
yes,
As to those charges, how do you plead, guilty or not guilty?
not guilty.
Ma'am, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
Invoke.
Okay? All right, let's go to Mr. Delancey, sir. Sir, what is your full name? How old are you?
27,
How far did you go in school?
high school.
Do you read, write, and understand the English language?
Yes, ma'am.
Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
No, ma'am.
Do you understand the proceedings that are happening here today?
Yes, ma'am.
Sir, are you familiar with the two charges that you're facing?
Yes, ma'am.
Do you understand those charges?
I do.
As to those charges, how do you plead, guilty or not guilty?
Not guilty.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
Waive.
Okay. This case is going to be assigned to Department 12. This case is going to have a status check trial setting in Department 12. That date is
It's gonna be January 15th at 8:30.
all right.
Judge, can I have you call, Mr. Thank you.
Yes. 12.
Co-defendant, Ms. Lopez.
All right, let's go to page 12 and 13. C, 388436, State of Nevada versus Daniel Roush. State of Nevada versus Gina Lopez. May the record reflect that Mr. Roush is present in custody. Mr. Horvath here on his behalf. May the record reflect Ms. Lopez is present in custody. Ms. McNeil is not present. Mr. DeGiacomo is here on behalf of the state. Mr. DeGiacomo?
Yes, Ms. McNeil reached out to me. She's in Elko. She asked me to make representations as she anticipates being ready
Okay,
for the current trial date and would ask that her presence be waived for this particular proceeding.
okay. Mr. Horvath, anything, are you on track as well?
Yes, Your Honor.
Okay, staying on track?
Yes, sir.
Okay, start check at 90.
Be April 9th at 9 a.m.
All right, thank you guys.
Okay, guys, so I guess they are taking a break and they're waiting for the sentencing. In the meantime, we are watching the Devyn Gonzalez trial.
Where were you when you heard these things?
In the restroom.
We'll be back to the Devyn in a minute.
Inside your
Inside
your
my
home?
house. Yes,
And you could still hear those sounds?
yes.
It sounded like a nail gun and then like a gunshot. So what did you do?
I went to my window.
Hold on, guys. There we go. Everybody's happy.
Describe what he looked like?
I don't remember.
Okay. Other than looking out the window, did you do anything else?
I took a video
And how did you take the video?
on my phone.
Okay. And is it a relatively short video?
I believe so. I don't really remember.
Okay.
Judge, we don't object to the video.
Okay. Thank you.
Custody, so of course has no problem continuing the trial. Well, my client is not.
Give it 18.
Dang it. Hold on.
And I'm gonna ask not to play it at
Figure
this
it
time,
out.
but to finish my direct and pass the witness and then play. That's okay.
If the court is going to
Got
grant the continuance, I would ask for a quick reset. And also, there's a Nevada Court of Appeals case, I think it's called Chittenden, which talks about how courts are to consider a defendant's custody status when granting or not granting motion to continue. My client's been in custody this whole time. I think when he was originally charged, he had a parole hold, so his bail was never actually addressed. So he's never had a bail set. So if you are going to grant the continuance, we definitely want to address the client's custody status, my client's custody status, so that he gets a chance to get out of custody as well. It just seems, off the top of my head, a little silly that the co-defendant who confessed to the murder and said that they did it alone has been out of custody this whole time. And my client, who has very little evidence tying to him, has been in jail this entire time. So we either want to go to trial as currently set and contest the charges, or if it's getting continued, we want his custody status to be set in something that actually gives him a chance to get out of custody.
Well, I mean, Mr. Guston, I understand all the points you made, but I want you to know I'm not sua sponte considering anybody's custody. So that issue has never been raised with this court, so it's never been considered in regards to your clients.
I understand.
All right, Ms. Levy, anything you want to add to?
Well, Your Honor, and I haven't been on this case for 8 months. Yeah, so I was appointed right before the last trial setting, and it was continued till this setting, which I said I don't believe that's going to be enough time. It was like 3 months or so for me to get ready over the holidays. There's absolutely no way I would be ready, and I told the court when it was set that I wouldn't be ready for this trial setting. I didn't receive discovery until after that, which is a large amount of discovery, multiple cell phone dumps, and I haven't had a chance to review everything. So there's absolutely no way I would prepare to go forward. Additionally, as this court is aware, I know the co-defendant's counsel is asking for a short set. This court knows that I start a 3-month federal trial on March 23rd in front of Judge Navarro.
What day?
March 23rd.
Okay.
So I will not be ready to go before then. I'll be preparing for that. That's a 3-month 11 homicide case in federal court. So I'd ask the court to continue. I mean, I'm obviously not going to be ready. So.
Mr. Merrill, what's the state's position on the motion to continue?
I have no opposition, and just in Ms. Levy's defense, there is quite a bit of discovery in this case, so I'm not surprised by her motion at all.
Okay. Well, I mean, Ms. Levy did indicate, and Mr. Jackson, I know that you were not on this case at that time either, so you weren't here. Ms. Levy did indicate to us when this was set that she could not be ready to go. This date was likely not viable, but she would be working to get ready, as well as at the discovery she doesn't have, she doesn't know what it is that she doesn't have, as well as you guys have indicated in the motions and everything you filed, there were still things coming in and there were things that were being filed. I know I still owe you a decision on the motion to suppress because these things happened in the last batch of discovery and you filed the motion as quick as you could. So I understand the January 15th date for the motion to continue and the calendar call will be vacated. The jury trial will be vacated, but I do understand where the defense of Mr. Smith is coming from. And based on the several motions that Mr. Vasquez filed in this case, I'm aware of the facts of this case. So I do believe that I understand where you're coming from in regards to wanting to consider your client's custody status. However, pursuant to the court rules, you have to do that in writing. And as I stated, this court has never been asked to consider your client's custody status, so I never considered it. You guys can file a motion, but what I am going to do is set this on for a status check because what we do with the trial date will determine what I do with the motion on your client's custody status. So do you think you can get it filed in a week?
We could file it by the end of the day, probably.
Okay, so you want to set it next, or do you guys want to, I can set it next Wednesday for you guys at 8:30, or I can set it, but it has to be at 8:30 because I have to sit down at 9, or I can set it next Thursday at 9.
Either day, whatever works for the court.
Okay, let's just set it next Thursday at 9 to make sure everybody's here, January 15th at 9, and it'll be set a status check trial setting in regards to Ms. Seniceros, and the status check trial setting and a bail motion in regards to Mr. Smith.
The only other issue to bring up today, so we've been requesting, so there's a lot of cell phone stuff and location data and stuff like that. We've retained an expert to kind of independently review and verify sort of the things that the state claims. In doing the cell site mapping, our expert indicated that they need the cell site list, the primer. You can only get that really from the detective. Ms. Red also reached out to the DA a couple different times. I think the DA, no problem with the DA. The DA's explained that she would try to get that for us. She's reached out to the detective a couple times. But my understanding is the detective just hasn't gotten back to her, hasn't given her the cell site list, the primer that our expert needs. So we just wanted to bring it up that we're having this kind of discovery related issue and see if we could get a court order that the detective provide that to the DA to give to us.
Well, I mean, I'm not gonna order the detective to provide it to the DA's office. I'm gonna ask Ms. Camaro to reach out, and if you think the court needs to intervene in getting that for you, then the court will intervene.
Understood, and I will represent that he recently, within the last few days, reached out to me. I just need to get on the phone with him now.
Okay, so you reach out to him, and if that's an issue, then I'll intervene.
The only other discovery-related issue that Mr. Costa mentioned was we've requested the complete DNA file as well. There's a part of it, evidence in the case that allegedly has our client's DNA on it. We want the whole DNA file to be able to give to. We've reached out to the DA. I don't know if there's an issue getting that or not.
We just got it, like
Perfect.
yesterday, I think.
Great.
So,
Okay, so that's
Send it
it.
over.
All right, and if there's something else, you guys can bring it up when we come back next week. Okay, and I promise you will have a decision by the next week on motion, I swear. I'm like, yeah, Judge, I heard that before, but I promise this time. So before I see you next week.
We know you've been busy and
Yeah.
we've all been busy as well.
Thank you guys.
Thank you, Your Honor.
Let's go to page 15, C 391028, State of Idaho versus Salvador Delgadillo. Let the record reflect the morning, Mr. Delgadillo is present in custody, Ms. Jackson is not present, Ms. Flake is also not present. This is their case together. They have been reaching out to my staff to reset the hearing in regards to the discovery motion, so we're gonna continue this until that date. Okay, because I'm pretty sure they thought this date was vacated, that's why they're not here. So this will be continued to March 5th.
Thank you. Your Honor, the attorney for Fields is here.
Who?
For Fields.
Okay. Mr. Moore, have you had any contact with Mr. Becker's office on rights?
I talked to Mr. Solinger, and he said he expected Mr. Devyn to cover for him.
Okay, well, she's not custody, so we can come back to it. Let's go to page 23. C 396529, State of Idaho versus Levi Fields. May the record reflect that Mr. Fields is present in custody. Counsel, can we have your appearance for the record?
Of course, Your Honor. Shaylin Dieter on behalf of Mr. Fields, bar number 16521.
All right, and Ms. Wilming is here on behalf of the state. This is the daytime set for initial arraignment. Counsel, are you prepared to go forward with the arraignment?
Your Honor, we are.
All right, Mr. Fields, sir, what is your full name?
Levi Christopher Fields,
How old are you?
29,
How far did you go to school?
graduated high school.
Do you read, write, and understand the English language?
Yes.
Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
No.
Do you understand the proceedings that are happening here today?
Yes.
Sir, are you familiar with the 3 charges that you're facing?
Yes.
Do you understand those charges?
Yes.
After those charges, how do you plead? Guilty or not guilty?
Not guilty.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right?
Invoke.
Okay? This case is gonna be assigned to Department 2. This case is gonna have a status check trial setting in Department 2. That date is?
January 13th at 9 a.m.
All right, thank you guys. Any update, Mr. Ryan?
Yes, she's on the way.
Okay, as soon as she gets out. Mr. Paul, can you approach on an unrelated matter?
Sorry.
Okay, now we got another break in the courtroom. We will be back in a minute. Go ahead and start sharing this.
Will get ejected out and get tossed depending on the gun, depending on the how much gunpowder is in it, it'll get tossed a certain distance on the ground. You can sort of guess as to how far away the
weird.
shooter could be. From
Okay. Hey, y'all, we're still waiting. We're over here watching the Gonzalez trial. We are still awaiting the Devyn sentencing. Thanks for holding with us.
All right, let's go on page 8, C 387854, State of Nevada versus Ricky Sanchez. May the record reflect that Mr. Sanchez is present in custody. Ms. Stanley and Mr. Gaskin are here on his behalf. Mr. Albright is here on behalf of the state. This is the date and time set for sentencing. Are both parties prepared to go forward?
Yes, Your Honor. Yes, ma'am.
All right, state you had noticed 4 victim speakers. Do you have 4?
is graphic. So you can see ICE agents stopping this SUV yesterday. One of them tries to open the car door. The driver reverses the car, then pulls away. Then a different officer in front of the car shoots. And seconds later, that SUV slams into a parked car. And that's the moment that shooting took place. The victim, I should say, has been identified as 37-year-old Renee Good. According to 2 federal officials, she was a U.S. citizen. City leaders say she served as a legal observer of federal actions in the city. Here's how local and federal officials are reacting to that deadly shooting.
They are already trying to spin this as an action of self-defense. Having seen the video of myself, I want to tell everybody directly, that is to ICE, get the f out of Minneapolis.
He doesn't know what he's talking about. It's very clear that this individual was harassing and impeding law enforcement operations. Our officer followed his training, did exactly what he's been taught to do in that situation, and took actions to defend himself and defend his fellow law enforcement officers.
Now, protests are erupting around the country. On the left side of your screen there is New York City, and on the right side, Minneapolis. And that is where we find CBS News correspondent Usher Qureshi. Usher, what are you learning about the victim? And the ICE agent involved in this deadly shooting.
Well, as you mentioned, she's been identified as 37-year-old Renee Good. She was a mother of a 6-year-old. We do understand, according to city leaders, that she was here as a legal observer, looking at what was going on here, observing federal investigations here in the neighborhood. And we're just a short distance away from where this happened, just a few hundred feet, Mugo. And over the last few hours or so, we've started to see the growth of people coming to visit this memorial where she was killed. As for that ICE agent, not much has been revealed about him. His identity has not been shared. They do tell us, we know from 2 federal sources that tell CBS News he's part of an ICE enforcement and removal operations team. DHS Secretary Kristi Noem said the agent was taken to the hospital and later released. But still, a lot of frustration, a lot of anger growing here in Minneapolis just one day after this shooting.
Yeah, and Usher, you are out there on the ground. So how are local residents responding to what just happened in their own backyard?
Yeah, absolutely. I mean, it's been very tense. Last night, very, very angry, frustrated crowds gathered. There are protests happening in other parts of the city. Where we are, it has been very...
Because I don't want to get in potential copyright violations, which I don't think I am. But I'm just going to be on the air on the side of caution. Why is this not sharing what I wanted to share? Oh, let me stop sharing. Restart this. Sometimes it gets a little glitchy when I have multiple lives going. I am sorry if you are over at the Devyn Michaels. I am so sorry that this is not working. I mean that it looks like they started the court. They started the Devyn Michaels live in the middle of the court dockets instead of waiting for her to actually go live. I am give me a minute. I'm looking for stuff over. We had other things that potentially could spin today, so I am looking for those. We had other sentencing that will be happening this afternoon. So nothing else is happening. I'm looking for something we can watch from Court TV. Because I know. Okay, we'll do this.
Welcome back. In our spotlight this morning, we're going beyond the glass at Nick Reiner's court appearance on Wednesday, how he looked and what happened. Reiner charged in the murder of his father, famous director Rob Reiner, and his mother, Michelle Reiner. Nick Reiner appeared in court for what was supposed to be his arraignment. We'll get into the legal wranglings in just a few minutes. But first, we want to talk about what he looked like. He walked in wearing a brown jail jumpsuit. Observers say that he was shackled behind a glass wall with his attorneys and that he peeked over the glass into the gallery. He was seen with sunken eyes, a shaved head, and facial hair. Reiner no longer wearing that protective vest that we saw him wearing at his first court hearing. After the hearing was over, his family issued a statement saying, quote, they have the utmost trust in the legal process and will not comment further on matters related to the legal proceedings. Now, we know Nick Reiner's attorney, Alan Jackson, withdrew from the case, and we're going to get to that a little bit later in our show. But right now, let's talk more about the impact that this case has had on Hollywood. I want to bring in now a special guest who's been following this case from the outset. She is the breaking news reporter for The Guardian. Danny Angiano is with us, waking up early on the West Coast. Danny, good morning. Thank you for being with us.
Good morning. Thank you for having me.
Of course. So I want to start with the impact on Hollywood, this case and the reach that Rob Reiner had, you know, in his career, the legacy that he has left. Talk to us a little bit, please, about what you've observed in the course of your reporting on this one.
Absolutely. Well, the killings have had just a really significant impact on Hollywood. It came right before the holidays, and Rob Reiner and Michelle Reiner were a legendary couple in Hollywood. I mean, I think so many people can think of a Rob Reiner movie that's their favorite. And so these were two really beloved legendary figures, and I think their deaths just sent shockwaves. They're so sudden and so violent, and I know a lot of people are grieving that.
Right, Danny. You know, and it all started on a fun night, as you know, at Conan O'Brien's Christmas party. They're with other, you know, celebrities and colleagues in the entertainment industry, having a great time. And then this, Danny, we're not hearing a lot about this party, and I know a lot of our viewers are so curious. Are you hearing anything more about what may have started the big fight that caused the Reiners to leave?
There's been some reporting. There's so much we don't know, but kind of what we have heard over the last few weeks is that there was some kind of party at Conan O'Brien's house, and that Nick Reiner was behaving unusually and making people uncomfortable. That's kind of been the reporting that's going around, and that there was some kind of conflict or argument underway there that unfolded that other guests heard. And, you know, it was well known that that Nick Reiner, I think, had some troubles, and then just a few hours later, they were killed.
Right. You know, and we know he's been a troubled young man for many years, Danny, and your reporting has touched on that. Would you kind of walk us through how great the effort was by Rob and Michelle Reiner to get him on the right path?
By all accounts, these were two parents who loved their children dearly. And in Nick Reiner's case, he was someone who had spoken openly about his struggles with addiction and with mental health issues. And his parents tried incredibly hard to get him the help that he needed. You know, numerous trips to rehab, and then 10 or so years ago, him and his father actually collaborated on a movie that was sort of based on, you know, his life and the challenges that he faced. And in doing so, we learned a lot about just how much effort they put forth, and, you know, the fact that oftentimes recovery in these things isn't linear, and that they didn't give up on their son. They tried really, really hard to help him.
Yeah, most definitely. And Danny, in terms of any indications of this, that homicides would occur. We know legally Nick Reiner's cloaked in the presumption of innocence. We know that. Investigators have indicated they're very confident that it was him, that he did this. They're not looking for anybody else. They believe that this was him and him alone who acted here. Were there any indications of him becoming violent or looking to target Rob and Michelle Reiner?
We have not heard anything about any prior history of violence or any acts of violence committed against them in the past. We have seen reports that there were previous police calls to the house in, I believe, 2019, and it seems as if those were connected to mental health, but there hasn't been any reporting so far that would suggest there was a history of violence. That said, law enforcement and the DA do seem very confident that this was the perpetrator. They arrested him, within hours of the killings, and the DA has said he's confident there will be a conviction.
Right. Danny Angiano, breaking news reporter for The Guardian. You've done such great work on this case. Thank you for coming on Opening Statements this morning. We'll look forward to talking with you again soon, we hope.
Thank you so much.
Take care. We're going to hit a break. When we come back, we're going to talk about the legal change. We saw defense attorney Alan Jackson withdrawing, not explaining why, though, saying something is beyond the control of his client, Nick Reiner. But what is that? Our attorney guest will weigh in.
What we've learned, and you can take this to the bank, is that pursuant to the laws of this state, pursuant to the law in California, Nick Reiner is not guilty of murder. Print that.
School shooting that broke hearts around the country and broke trust with law enforcement.
Now, the officer sworn to protect those students faces a jury.
The Uvalde School Massacre Trial. Live coverage today on Court TV. 8 hours of back-to-back true crime cases every Saturday.
This is crazy.
On America's original true crime obsession. 48 hours on Court TV. Saturday starting at 4/3 Central on Court TV.
Upon entering the residence, they discovered the bodies of Mr. and Mrs. Reiner. Detectives from our Robbery Homicide Division Homicide Special Section immediately initiated a comprehensive investigation. The evidence gathered led to the arrest of their son, Nick Reiner, who was taken into custody later that night without incident in the Exposition Park section of our city.
Because at the appropriate time, the actual evidence involved in this case will be presented in a court of law.
So there's a major shakeup in the murder case for Nick Reiner as his attorney, Alan Jackson, resigns from leading the defense team.
Your Honor, at this time, I, on behalf of Workman Jackson and Quinn, and with Mr. Reiner's understanding and consent, would ask to withdraw as counsel of record based on the conversation that we've had in chambers and the explanation we've provided to the court in chambers. We feel that we have no choice at this juncture but to withdraw as counsel and ask to be relieved. The Public Defender's Office has been notified. We've had conversations with them. They are here, they're staffed, they're ready to take over. My understanding is they are ready for the appointment immediately.
Deputy Public Defender Kimberly Green, who serves in Los Angeles County, this is her, is now taking over as the lead defense attorney for the 32-year-old Nick Reiner, whose arraignment was postponed again. Now it's going to happen on February 23rd. So a lot of people buzzing about what comes next. Why did Alan Jackson withdraw? Okay, that's privileged information, as he indicated to both the court, who knows, they had chambers discussions, meaning behind closed doors with the judge, but to the public, he can't reveal why. But we can draw on our experience and provide some educated guesses as to why. So to help me do that, let's bring in our legal analyst guest this morning, attorney John Phillips, who is a celebrity attorney, does criminal defense work as well as civil work. Okay, John, so your initial thoughts after hearing what Alan Jackson said to the court. What do you think was going on there?
I've been making a lot of notes, so I'm going to start with his press conference, and don't. I hope I don't get your questions out of order. But he said twice, pursuant to the law, pursuant to the California law. He didn't say his client was innocent or his soon-to-be former client. So that kind of tells us there's going to be a premeditated dispute, right? A dispute over premeditation. And then what he told the court, and basically how these things work is when you're trying to discuss attorney-client privileged information, you go into an ex parte room with consent with the judge and say, Judge, he can't pay me. Or, Judge, this is my issue with a conflict. But I think we can draw on the conclusion that he's indigent enough to have a public defender, that Alan Jackson, as much as he may want to take this case, can't afford for his team to be able to take this case and operate at their standards financially.
Sure. That is a very real possibility, John, that Nick Reiner may not be able to afford the legal fees. That is quite frankly very possible. So that could be one possibility. Number one, it could be money that caused this. Number two, John, what do you think about a conflict of interest? You know, when a firm has to look at who they've represented in the past, and if there's anybody who's going to come up as a witness or someone in the case, and there's a conflict that you just can't get around, wondering if could that be it? He didn't say the word conflict, although I don't know why he wouldn't if it was truly a conflict. I'm more inclined to think it was your first guess, money, but would you speak to that? You think it could be a conflict of interest?
Yeah, the two things that I would analyze on conflict of interest is one, again, he's going from a paid, expensive attorney to public defender, which requires indigency. So that tips me away from that. But second, when we're doing conflict checks before we get involved, and we're required by every bar in the country to do a conflict check, we're supposed to do that before we start representation. Certainly conflicts can arise midstream, but on a high profile case, you know, let's say when I was representing Joe Exotic, I'm not running around, you know, grabbing other Tiger cases or representing the prosecutor, or you know, you stay linear. You keep your oath of loyalty to this client, and so I don't think a conflict arose. Now it could be that one was pointed out. Oh, oops, I forgot, or my partner represented this, you know, Rob, the decedent. But again.
Getting underway. I am having sweet potatoes for lunch. Just mashed sweet potatoes. We'll have to go back and edit the video for this trial and cut out all the dead time. Ari, make sure we put in my humble opinion. We all need to put my humble opinion, actually. I'm sorry, I'm so hard to refrain from commenting. Okay, while this is going on, I'm going to continue to eat my lunch. I'm still here.
That's where the grab my water.
Take her back there. We're gonna talk to her. Michaels.
What the heck is happening? Okay, we are waiting for the sentencing for Devyn Michaels. They have brought her in and sat her in the jury box, and then now they have brought her out of the jury box and cleared the room yet a second time. Y'all, I don't know what's going on. Also, for those who don't know, my sister's memorial will be this weekend, so I was on the phone with my sister's other brother, and we had to deal with some things, so apologize. But y'all, this is getting ridiculous, man. I don't know what's going on with the Devyn Michaels case.
All right. Let's go on the record and see 377239, State of Nevada versus Devyn Michaels. May the record reflect that Ms. Michaels is present in custody. Mr. Droskich and Mr. Horvath are here on her behalf. Mr. Giordani and Ms. Griffith are here on behalf of the state. This is the date and time set for sentencing. Are both parties prepared to go forward?
We are.
All right, just a couple housekeeping matters. State, the victim's mother sent a very long, detailed list of money she's out of, but I don't have any documentation
I did
to
not
support.
receive that.
Okay, so I'm gonna award the $5,000 of restitution to victims of crime, but that'll be the only restitution because there was actually proof of that.
Understood.
Any objection from the defense to that?
No, Your Honor.
Okay, and we did have a discussion about credit, and we have the credit at 780 days. Is that correct?
That is correct.
Okay. State, you also noticed victim speakers. How many speakers do you have?
2.
And pursuant to statute, would you like them to speak last?
Please.
All right. State, since this is the result of a jury trial, you have retained the right to argue.
Yes, Judge, and you've been doing this as long as I have, if not longer. There's a couple of different types of defendants that come before you and that I've dealt with in my career. And there are those that don't function in society. They commit multiple crimes over and over. And then there are those like this defendant who functioned relatively normally for an extended period of time, but committed such an extreme act of evil when she did commit a crime that you have to put her on the far end of the spectrum of evil, Judge. I understand that her lack of criminal history is something that you're going to take into consideration when you determine whether she gets life without her or not. I really just have a question for the court, and I'm not going to try to provide an answer. And the question is this, is a person who is capable of such extreme evil, is that person someone that we want to walk our streets, whether it's 20 years from now, 28 years from now, or not? And you're in the row, you're on the bench, you get to make that decision today. I would just urge you to think about what it must have taken for her to do what she did. Not everyone is capable of that extreme amount of violence. Not everyone, not even some of our worst offenders go that far. There was some statements made at our last sentencing that I would ask you to take into context with the evidence you heard at the trial. There is absolutely overwhelming evidence of her guilt, and obviously we have a jury verdict at this point. So all that nonsense that was spewed at the last hearing, I think that has been disproven during the course of the trial, and as evidenced by the very quick verdict that was delivered in this case. If you'll recall, it was just a couple of hours on the same day of closing arguments. With that said, Judge, I will submit it to your discretion, just defer to the victim speakers.
Okay. Ms. Michaels, what, if anything, would you like to say before I pronounce sentence against you?
At this point, I just feel that anything I say, it won't. The family's looking for certain things, and I cannot deliver what the family's looking for. And they're here, and I just want them to get their, at least part of their anger out. I know no matter what I say, they're still gonna feel the same way. So just let them have their time, and that's all I can say.
Thank you.
Your Honor, I like the state, am going to be somewhat brief. This was the result of a 2-week jury trial. I do appreciate Ms. Michaels' statements and even the lack of her statements. This case has had a bit of a wild ride to get where we are before Your Honor today. You know, the jury, and we all spoke to the jury afterwards, looked at basically one thing, and that was her statement to the police on August 15th. And she has made several statements leading up to this point, and today she's chosen to just basically let the record speak for itself and then the history of this case speak for itself. You know, Your Honor is in a very unique position, being basically a murder trial judge. The thing that I would like the court to take into consideration is the issue of proportionality. You know, you hear on a regular basis cases that involve years, if not decades, of criminal conduct. People that have substantial criminal histories. People that have committed crimes over and over and over again. Ms. Michaels has a gross misdemeanor conviction that was close in time to this case, relatively speaking. She, outside of the events that gave rise to this case, she's lived a very good life. And I think the court should take that into consideration in reference to this issue of proportionality and treating similar defendants similarly and different defendants differently. I mean, when we look at the object or the goals behind sentencing, we have deterrence, you know, we have incapacitation, we have rehabilitation, and then we get to this issue of retribution. And, you know, the flip side of retribution is redemption. You have a woman that stands before you today who's 47 years old. She turns 48 in April. You've got a woman that was a devoted mother. She had a career. Obviously, what occurred is not going to bring Mr. Willett back. Miss Michaels' case, if we take the version of events that the state presented, we have here, you know, you talk about stabbings and crimes of passion and things like that. You know, in this case, we don't have someone that's been charged with lying in wait, planning. We don't have a case where we have a life insurance policy that was viewed. You know, we don't have this, and when we talk about evil, I mean, that's kind of a slippery word sometimes. But at worst, what we have here is a conviction based on impulse and then perhaps bad actions that occurred following that. Your Honor spoke with the jury, we heard the testimony. We had this, and she was charged murder with use. And if we take the evidence in the light the most favorable to the state, we have something where there've been unwanted sexual advances. There was a candlestick or perhaps a poker that was then used to strike Mr. Willett. And I'm using his name. I mean, the decedent, you know, I don't want to minimize, he was a person, obviously, as is Miss Michaels. We have, again, we have an appeal that's going to follow, but nonetheless, if we take the version of events that the state would have the court take into consideration, we have an act that was based on impulsiveness and then bad case decades. We have a single act that's now before Your Honor. You know, the very minimum sentence per statute that Ms. Michaels could receive is a 21-year sentence. We're talking 60 years old. And Your Honor knows the studies. I mean, like I said, you're in a very unique position based upon your experience and the depth, not only off the bench prior to your having assumed the bench, but as a murder trial judge. This is a case where the court should look at redemption. She can contribute to the community. She's had no issues whatsoever while incarcerated. In the beginning of this hearing, Your Honor addressed the credit for time served she's been in for some time. I would urge the court to view, you know, to look at the facts and circumstances and the very difficult decision Your Honor has to make with the idea of redemption in mind. I would urge the court to give her as far as the murder charge, the chance at redemption, the chance to be perhaps one day reincorporated into society. I would urge the court to give her a sentence of 20 with the possibility of parole, and then the minimum sentence for the with use in enhancement. I would submit that this idea of proportionality and true equity and fairness would be served by such a sentence, and that's what we request. And on that, I submit it, Your Honor.
Okay, thank you. State your first speaker.
Feller.
You do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God. Please state your full name, spelling your first and last name for the record.
Valeria Willett, Valeria Willette.
And ma'am, what would you like to say to me today?
First of all, thank you for giving me the opportunity to speak out. It's been a while, and I'm very thankful. And whatever I'm going to read is what I lived for almost 3 years.
Okay.
Excuse me. The brutal murder that took place on August 7th, 2023 has forever changed my life, my husband's, and my children's life. I am still in shock and traumatized because of this unbelievable act from someone who is selfish and heartless. About a week after Jonathan's murder, we came across a huge responsibility of taking in 2 young girls who we didn't know, and due to the circumstances, we couldn't say no when all others say they couldn't. My life has changed since the notification of my stepson's death. With us taking in 2 girls with us taking 2 girls in our home and getting to know them and not knowing of all the trauma they previously had, after the murder, even more trauma was added. It has been a tough 2.5 years for all my family. Grieving has been hard at home, since there were times when I needed to break down and cry, but I couldn't because we had 2 girls who depended on our strength. Along came caseworkers, CASA, Boys Towns, and CAP attorneys who visit our homes several times a month. This doesn't include the process of getting fingerprinted, classes to be able to assist the girls while with us, and therapy for them and myself, husband on a weekly basis. The girls did not have discipline, boundaries, basic cleanliness, social skills, and proper hygiene. The clothing they brought from Child Haven was unfit for anything except playtime. I contacted their stepfather/brother, Devyn, to see if we could pick up more clothing, and those were not much better. We ended up spending a lot so they could look presentable when in school and out in the community with us. We also had to deal with Casey, our daughter, who was in senior year and fell into depression, making it hard for her to be in school and caused a lot of absences. It was a huge change in her life, having to deal with 2 young girls with so much trauma and issues. Our family has pushed through, and Casey graduated in June of 2024. It has been very hard on us since no other relative has assisted us in caring for the girls, only my immediate family members, which are my adult children. We have now built a relationship with Aunt Kayla, the killer's sister. She stopped by while she was in Las Vegas on business, and we had a great conversation, and she departed as a supportive aunt. Because of this meeting, the girls have changed their minds of what kind of person she is. We will continue to nurture this relationship with Aunt Kayla and the girls. Through Jonathan, we have gained a true friend who has supported us, especially me. We grieve together, and Bernadette has also lost a best friend. We talk, cry, and express our sorrows about how a person was taken away so brutally. We cannot bring Jonathan back. God has gained an angel in heaven. We believe he is watching over us and the girls. I ask today for justice for our family, especially the girls, because we have been sentenced for life with this tragedy. This will follow them for the rest of their life. We've created a time capsule for them in therapy where they can place notes or items that they can open in the future to remember their journey. We will never again hear his voice, his laughter, or see his expression. Jonathan doesn't have a second chance. His life has been taken, never to return to us. The girls have been left without a dad, stepfather / brother who doesn't make contact with them, and a mother who's in jail. After my marriage of 14 years, I have come to know Jonathan. Although we didn't have a close relationship with him, I miss his jokes, laughter, and him being funny. He would come around on holidays and enjoy our time spent with him. Thank you for allowing me to speak about the situation, and I am seeking the hardest penalty in this case. The killer that ended Jonathan's life needs to be put away forever. Thank you.
Thank you very much, ma'am, and thank you for being here today.
You do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your full name, spelling your first and last name for the record.
James Willett, JamesWillette.
And sir, what would you like to say to me today?
I have a prepared statement that I would like to have you listen to.
Okay, whenever you're ready.
May I have a seat?
Sure.
Your Honor, I must apologize as I'm uncertain of the appropriate name to use. Tracy Reed, Tracy Tavares, Tracy Baker, Devyn Michaels, Nikki Fairchild. But for clarity in this context, I will refer to her as the killer and murderer of my son, Jonathan.
Y'all, she's the corn star. This is a woman who went by a lot of names. And she's tied to the Cemetilli trial.
This horrendous murder crime has affected her two precious children, myself, my wife, and my children in the household, my wife's mother, my wife's brother and sisters and their families, my ex-wife and her boyfriend, my remaining son, my grandson who married her, his mother and family, her parents along with her sister's family, and anyone who knows us or were friends with Jonathan. We have all been given a life sentence by a woman who doesn't respect life. She has removed from our lives my son, her daughter's father, her daughter's stepbrother, and all related individuals that were just mentioned. The enduring loss of opportunities to communicate with Jonathan, witness his achievements, and provide guidance is permanent. This absence is not limited to life without parole. It is not replaceable. Each day serves as a reminder of this lasting impact, which will persist indefinitely. Regardless of the duration of her sentence, we continue to experience an ongoing sense of loss that will endure throughout our lifetimes. Our circumstances remain unchanged, and correspondingly, there should be no alteration to hers. As we grapple with the magnitude of what has been lost, we find ourselves thrust into unfamiliar roles and responsibilities, forced to adapt and preserve in the face of relentless adversity. The routines we once knew have vanished, replaced by an ongoing quest to provide love, safety, and guidance for young lives so suddenly uprooted. Our whole household has become a place of both deep sorrow and determined resilience as we navigate the labyrinth of legal proceedings, therapy appointments, and daily challenges that arise from a tragedy of this scale. The weight of grief is compounded by the necessity to advocate fiercely for our grandchildren, ensuring their emotional and physical needs are met, even as we contend with our own sense of devastation. Despite the overwhelming nature of these circumstances, we are steadfast in our pursuit of healing and justice, propelled by a profound sense of duty to honor Jonathan's memory and to safeguard the well-being of those he cherished most. The tragic passing of my son, Jonathan, has had a profound impact on many individuals, including his two beloved children, his mother, our family, all relatives, the killer's parents and sister, as well as friends and acquaintances of his. We have all received an extreme life sentence, not a 15-year to life term. We have no parole. We just the knowledge and the heartbreak of his loss. The killer, who does not respect life, has taken away my son, her daughter's father, her daughter's stepbrother, who is also her husband, and all others mentioned. The opportunity to communicate with my son, appreciate his life, witness his achievements, and provide support through advice is permanently lost. Every day we are reminded of this irreversible consequence. Nothing will change in 15 years, 20 years, or even our lives. Regardless of any duration served by the killer, Jonathan will not be returned to us. His actions are permanently ceased, and his voice will remain silenced forever. We are enduring a lifelong impact until the end of our days. This situation remains unchanged for us and thus should remain equally unaltered for the killer. We are consistently reminded of the serious impact of the killer's action on her life. Each day, the killer's daughters wake up to the reality that their father is no longer part of their lives, preventing them from sharing any experiences or creating memories with him. They experience significant long-term effects due to growing up without parental support, relying on grandparents, relatives, and others for assistance during a limited period before achieving independence. We are optimistic that they will understand they are not responsible for these circumstances and their future choices will help them avoid entering this system. Despite this, they will carry the burden of their mother's actions, knowing she has effectively removed both parents from their lives. These events have left two young lives facing significant challenges in their futures following the loss of their father due to her mother's actions. The recent events have been particularly traumatic for our family, especially for the children. My wife and I have attended classes to assist in raising our granddaughters and addressing their trauma. We are supported by caseworkers, CAP attorney, CASA worker, Boys Town worker, therapists, special school classes, coaches, and the daily challenges resulting from the loss of both parents. This situation has impacted everyone involved. We have observed changes in attitudes of our relatives and friends due to this event. Both my wife and I have consulted a therapist for support, which has been beneficial, though the issue remains prominent in our lives every day. We have attended numerous court dates related to both the murder trial and the cases involving the child abuse and termination of parental rights. The significant time spent traveling, communicating with district attorneys, and enduring the anticipation of trial outcomes has severely impacted our mental health and well-being. Such experiences are immensely challenging, particularly when one child is tragically taken by murder, as Jonathan has. As a retiree, I anticipated enjoying my golden years, but now my wife and I find ourselves responsible for raising preteens once again. It is essential to emphasize that while we deeply care for the girls and are concerned about their future, proper medical care and dedicated personnel can help ensure they lead normal lives. We are making notable progress with Janaea, who is determined to improve her life and situation. Despite holding 3 licenses, foster kinship, relative foster home advanced foster care, and professional caregiver pre-service training, we continue to enhance our understanding of the trauma experienced by our granddaughters. These children have never experienced loving discipline, nor had real interaction with others, as they were homeschooled rather than attending school. Consequently, there is a significant lack of etiquette in social environments and personal interactions with peers and friends. This is especially difficult for us in a family setting or gatherings on special occasions. Throughout this difficult and painful experience, our resilience has been tested beyond measure as we navigate the complexities of the judicial system and endeavor to provide a stable environment for our granddaughters amid relentless adversity. The emotional and practical burdens we bear have transformed our daily existence, challenging us to find strength in one another and in support systems available to us. Despite the constant reminders of the loss and the enduring pain etched in every aspect of our lives, we strive to foster hope for the future of our grandchildren, advocating for their safety, well-being, and justice in the wake of such irreparable harm. We have faced countless obstacles in our efforts to piece together a sense of normalcy, persistently navigating bureaucratic hurdles and emotional turmoil while striving to safeguard the children's well-being. Every aspect of our daily existence has been altered. Every future plan reshaped by consequences of a single unforgivable act. The weight of responsibility continues to rest heavily upon us as we advocate for justice and stability, not only for our own heart, but for most importantly, for Jonathan's children whose futures have been so deeply scarred. We are requesting, per Marcy's law, the Senate Joint Resolution SJR Section 1, letter G, to reasonably notice of all public proceedings, including delinquency proceedings, upon request at which the defendant and the prosecutor are entitled to be present, and all parole or other post-conviction release proceedings, and to be present for all of these proceedings. Section N, to be informed of all post-conviction proceedings, to participate and provide information to the parole authority, to be considered before the parole of the offender, and to be notified upon request of the parole or other release of the offender. Section P, to have all monetary payments, money, and property collected from any person who has been ordered to make restitution to be first applied to payment to pay the amounts ordered as a restitution of the victim. As we move forward, it remains imperative that the lifelong consequences endured by our family, and especially our grandchildren, who will endure this crime for many years, are gone, are met with unwavering commitment to accountability and truth. The emotional scars, the logistic obstacles, and the persistent sense of emptiness cannot be erased. But through steadfast support and continued vigilance, we hope to honor Jonathan's memory and instill a sense of security and justice for his daughters. We deeply care for our grandchildren and find it challenging to come to terms with the actions taken by their mother, both regarding our lives and more significantly, those of her children. The impact of this trauma may have lasting life on them. For instance, there is uncertainty who will accompany them during important events such as walking them down the aisle, at their weddings, graduations, birthdays, etc. There are moments in life when one must pause to reflect on one's circumstances. We examine all the known facts and attempt to understand them. My spouse and I have attended the court hearings related to both the termination of parental rights and the criminal case. This planned and calculated murder, and remind it was planned and calculated, is not justified in any way or manner, and the killer needs to be incarcerated for the rest of her life. We respectfully request that the maximum penalty behind bars without parole be imposed for this heinous crime. We consider the act of killing and decapitating the father of the killer's children and husband to be egregious and extremely severe and should be met with extremely severe punishment. We trust in the wisdom of the court to recognize the full impact of these actions on all parties involved and to deliver a resolution that both acknowledges the depth of our loss and upholds the principles of justice upon which our faith now rests. Thank you for providing me the opportunity to share my perspective on this criminal murder. I now defer to your judgment on this murder case.
Thank you, sir, and thank you very much for being here today.
No parent should be in that position.
Well, I think when Mr. Draskovich said it's been quite a roller coaster that got everybody here, I think that's quite an understatement as to how we got here. But I did preside over this trial for 2 weeks, and I was able to hear all the evidence that was presented by the state, as well as I was the judge when this case was originally negotiated at a settlement conference, and then Ms. Michaels wanted to withdraw that plea and proceed to trial. And the jury has ruled, and we all have to respect the decision of the jury. But I have to say, and I think Mr. Willett said it best, and as well as so did his wife, because one of the biggest concerns that I think we should all have as we deal with this is the fact that these children are going to be left without either one of their parents. And it's not any fault of theirs, it's not anything that they played a part in, but as well as everything that they had endured up to this point. And now, Ms. Michaels, based on your actions, they are going to be left without either one of their parents. Pursuant to the jury's verdict, you're going to be adjudicated guilty of first-degree murder with use of a deadly weapon. In addition to the $25 administrative assessment fee, your DNA was taken in 2022, so it's waived. The $3 DNA assessment fee, you're going to be ordered to pay $5,000 in restitution to victims of crime. You're going to be sentenced to 240 months to life in the Nevada Department of Corrections. There's going to be a consecutive 96 to 240 months in the Nevada Department of Corrections for the deadly weapon enhancement. And as of today, you have 780 days credit for time served.
Thank you.
Thank you. Mr. Draskovich, your office will be allowed to withdraw at this point.
Okay, she said it so fast, I'm going to repeat it. You're going to be serving 240 months, 20 years to life in the Nevada Department of Corrections. There's going to be a consecutive, not congruent, 96 to 240 months in the Nevada Department of Corrections for the deadly weapon enhancement. In other words, 40 years to life. No, 20 years to life. So after 20 years, she can apply for parole. She won't get
Mr.
it.
Brown, we are going to appoint you as appellate counsel so that you can file the notice of appeal. Yes, you can put it. Thank you, Doctor.
She went from being a Cone Star to a prison star. Congratulations, boo. Cone Star to prison star. I love this. 3 cups. I think it holds 4 cups. I'm almost out. Yeah, I'm almost out. Do what I'm going to do. I think I'm going to switch to coffee. I'm going to switch to coffee. I love my tea kettle. It's full. Love my tea. So we are still waiting for court to resume in the Uvalde shooting. Tomorrow I will have to be remote in the morning. My daughter's car broke down. I will be having to drive to go pick her up from college and bring her home. It's a 5-hour round trip. We're ending the poll. The first poll that we had, do you believe the jury realistically is able to set aside Mrs. Hale's testimony in the case in the Valde trial? No, 58%, 42% yes. Do you think that Devyn Michaels should have taken the plea deal? 89% yes, 11% said no. I like this attorney. So he's probably explaining to her. He is probably explaining to her what she got. And he's also explaining to her that he will be the appellate attorney, and then he will have to hand it off. Hello to Banana. How many years to the plea for? I think it was, I don't know. Let me look up my notes. I know I have notes. All right, so now we have another case that we're not following. I thought I would have been close, 15 years to life. The plea guilty for the second degree would have been 15 years to life. So her plea deal would have allowed her potentially to be paroled at 15 years and for her to, but now it's 20. Yeah, boo, you should have stuck with the plea deal. You thought you were going to get a better chance with this, but I'm sorry to say you did. I'm not sorry. I'm glad to say you did not. So Devyn Michaels is done. Okay, guys, everybody on the Devyn Michaels side, thank you so much for joining. I will trim this down. I will edit this video. I don't know why the court did what they did, but they did something stupid and crazy. So we're going to go back or not the court, a live feed. So I will go back and edit this down. Thank you so much for joining. Y'all have a fabulous the rest of your day. Come join us over at the Uvalde School Massacre Trial. Getting ready to start in a few minutes. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time.